Hello friends, let us discuss citizenship that is included in the part 2nd of the Indian Constitution. So, what is citizen? A citizen is a person who enjoys full membership of the country or full membership of the community in which he lives or ordinarily lives. The state demands extra duty from its citizen which cannot be asked to a non-citizens. 42nd Constitution Amendment Act 1976 has inserted 10 fundamental duties in Article 51A. So, what are the ways to acquire citizenship? The Constitution of India under Citizenship Amendment Act 1986 provide 5 ways to acquire citizenship in India. The first one is citizenship by birth, second one citizenship by descent, next one citizenship by registration, then citizenship by naturalization, then citizenship by incorporation of territory. So next part third, that is fundamental rights. So what is fundamental rights? Fundamental rights are justiciable, allowing a person to move the court for their enforcement if and when they are violated. They are defended and guaranteed by the Supreme Court. Hence, the agree person can directly go to the Supreme Court. They can be suspended during the operation of national emergency, except the right guaranteed by the Article 20 and 21. More, the sixth right guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of external aggression or war. So originally, the Constitution provided 7 fundamental rights. That is right to equality, that is included in the Article 14 and 18. Then right to freedom, Article 19 to 22. Right against exploitation, that is Article 23 and 24. Right to freedom, Article 25 to 28. Cultural and educational right, that is mentioned in the Article 29 and 30. Right to property mentioned in Article 31. Right to constitutional remedies, that is Article 32. However, the right to property was deleted from the list of the fundamental right by the 44th Constitutional Amendment Act 1978. It has been made a legal right under Article 300A in the Constitution. So, at present, there are only 6 fundamental rights. To enforce the fundamental right, the Supreme Court and the High Court is empowered under Article 32 and 226 to issue writ of various form. So what are the writs or what are the forms of writs? The first one is habeas corpus. Habeas corpus literally means to have the body. It implies that a person in prison or detained by the law can inquire under what authority he has been imprisoned or detained. The court issue the writ against the authority concerned if the executive arrests someone without the authority of law or in contravention of procedure established by law. Next one is mandamus. Mandamus means it is command issued by the court commanding a person or a public authority or forbid to do something in the nature of public duty. The writ of mandamus can be issued by court to enforce fundamental right wherever a public officer or government has committed an act violating a person's fundamental right. The court can restrain that authority from enforcing such order or committing an act. Next one is quorum. An order issued to the court to prevent a person from holding office to which he is not entitled and to oust him from that office. Next one is provision. The writ of provision is issued by the Supreme Court or a High Court to an inferior court, forbidding the latter to continue proceeding in a case in excess of its jurisdiction. Next one is certiorari. The writ of certiorari is issued to a lower court after a case has been decided by it, quashing the decision or order. So the objective to secure that the jurisdiction of an inferior court or tribunal is properly exercised and that it does not usurp the jurisdiction which it does not possess. Next one is directive principle of state policy, that is article 36 to 51. The directive principle of state policy denotes the ideals that the state should keep in mind while formulating policies and enacting laws. It includes the legislative and executive organs of the central and state organization, central and state government, all local authority and all other public authority in the country. So the DPSP or directive principle of state policy are non-justiciable in nature. Therefore, the government cannot be compelled to implement. They aim at providing social and economic justice to the people. So this is all about citizenship, fundamental rights, forms of writ, and directive principle of state policy. So friends, we'll discuss in the next video fundamental duties, election of the president, impeachment procedure of the president. So please like, subscribe and share my channel TS Education Online. Thank you.